Good afternoon, everyone. On behalf of UP Solair, let me welcome you to this very important forum on the welfare of our seafarers. We will be tackling the rights of foreign seafarers, that includes our own Filipino seafarers who are working on board vessels that has its own home port in the Netherlands, to receive the Dutch statutory minimum wage and its implications to the Maritime Labor Convention. The topic is very important and very timely because today's headlines in the Philippines refer to Philippine seafarers. Inquirer, for one, in its banner headline states 50,000 Filipino seafarers are at risk of job loss on EU vessels. It is also worth mentioning that the Philippines is a major source of seafarers worldwide, and that the maritime industry is one of the most popular career goals for Filipinos. Yeah, our topic this afternoon is towards that direction of focusing on the rights of Filipino seafarers. We welcome in this forum our 100 plus participants, consisting of representatives from maritime employers, the seafarers themselves, seafarers unions, the academe, the government, and the private sector. We also welcome our distinguished guests, namely Ms. Kirsten Bule of Waibenga Advocates in the Netherlands. She's our keynote speaker for this afternoon. Attorney Emmanuel E. Partido of the AMUSUC, an affiliate of the International Transport Workers Federation. Attorney Francis Ron de Guzman, Assistant Secretary for Licensing and Adjudication of the Department of Migrant Affairs. Attorney Generic Humphrey Morales of the Associated Philippine Seafarers Union, or APSU, also an affiliate of the International Transport Workers Federation. And last but not the least, we welcome Captain Juanito Jean Salvatierra Jr., who is the chairman of the Joint Manning Group, a crewing agency association in the Philippines. We also greet our co-partner for this event, our friends from Marino World Online, with special mention to Ms. Lynn Bacani. We will have an engaging discussion of our topic with our participants and guests. Finally, before we start, may I plug in our academic program in UP Solair, which is a master's degree in industrial relations, with areas of specialization in labor management relations, human resource development, and labor policy advocacy. We are still accepting applications for next semester until November 14, 2022, just in case. No, you just visit our FB page or our website. We also plan to include a short-term course specifically on seafarers. Okay, on behalf of UP Solair, I welcome all of you to this very important forum. Good afternoon, everyone.
Thank you again, Professor June Aragon. We have now more than 60 in the room, and I think the others are still coming in. But in the meantime, may I hand over the hosting of this program to my colleague, Professor Ben Velasco, who will now introduce our speakers, starting with our main guest from the Netherlands. Ben, Professor Benji, please.
Yes, thank you, Professor Amante. So good day to everyone. So again, this is a webinar on seafarers minimum wage in commercial vessels in a Dutch home port and its implications for the Maritime Labor Convention. Okay. Our main speaker for today is a distinguished guest from the Netherlands. So Kirsten Bull is a partner at Waibenga Advocaten and has been with the law firm since 2011. Waibenga Advocaten is a law firm based in Rotterdam with the motto, "Advice with a focus on the future." It seeks to provide legal services and advice with a long-term focus and aims for results that will continue to satisfy over time. Kirsten specializes in employment and maritime law. She advises shipping yards, ship owners, employment agencies, companies active in Dutch ports, works councils in the maritime sector, and also crew members. She has clients active in maritime trade, the offshore sector, shipbuilding, the yachting industry, and even fisheries. In addition to regular employment law, Kirsten also advises on the legal aspects of working in the maritime sector. For example, on international employment construction, aspects of the Maritime Labor Convention, collective agreement matters, and enforcement cases, such as challenging fines imposed for violating the Foreign Nationals Employment Act. Assisting organizations in complying with the labor law regulations is an important part of her practice. She also advises about the registration of ships and flag-related aspects. Finally, Kirsten has a varied attachment and execution practice, often in an international setting. So, welcome, Kirsten, and you have the floor.
Hello, thank you for this elaborate introduction, and thank you sincerely for inviting me to give some more information about an important Dutch case that this forum is centered around. I welcome everybody for attending. I'm very glad to see so many people interested in this topic.
It's working fine. We can see the full presentation.
Right. So I'm going to take this first 15 minutes to explain a bit more about this case. I could talk for hours about this case, but I'm only adjudicated 15 minutes, so I'll keep within the regulations of this forum. Is it now continuing? Oh, yes. So at the center of this court case is, well, what is important is that the ILO minimum wage, which is basically referred to as the international minimum standard of basic wages, according to the ILO, is around $650. In the Netherlands, we have a statutory minimum wage, and that statutory minimum wage is much higher. It is around 1,750 euros. So at the center of this case is the question whether the seafarers in this case are to be paid the Dutch minimum wage, which is much higher. And I'm sure we'll talk about the implications hereof in the rest of the forum. I am only going to talk about this court case. So the Dutch Minimum Wage Act in the Netherlands has two goals. It is first an important act to ensure that an employee has sufficient income to basically make a living, to pay mortgages, to support his family, etc., his or her family. The second goal of the Dutch Minimum Wage Act is to protect the Dutch labor market in terms of employment possibilities, but also ensuring that there is a certain level of employment conditions. The idea is that by way of setting a statutory minimum wage, you avoid a negative wage spiral. So basically what we know in the sector as the race to the bottom. These are the two main goals. And because these goals are considered so important, the Dutch Minimum Wage Act is a mandatory priority rule in the Netherlands. It is of public order. And basically this means that it supersedes the conditions of the employment agreement, and it supersedes the CBAs. It is of that importance. The third part that is important to know about this Dutch Minimum Wage Act is that we refer to it as a scope rule, and this act has its own territorial scope. So the act itself defines to which employees it is applicable. Now, the facts. because it's only a ruling in this specific court case. The case deals with, there were seagoing vessels. So this is important to know. These vessels were seagoing vessels, were registered in the Dutch ships registry, flying the Dutch flag with a Dutch ship owner. The ships were relatively small, they're towage tugs, and they mainly do port towages. So they take a vessel at sea and guide it back into the harbor. This is why I also added a picture of the Amsterdam port. This is where these towage tugs mainly operate. They take a big seagoing vessel at sea and they guide the vessel, tow it back into the port. They don't only did that in this court case in Dutch ports, but they also incidentally did some towage activities out at sea. And also for a few months, maybe they were doing towage activities in UK ports. So not only in Dutch ports. There's a relatively small crew on board this vessel of a few crew members. It was mostly a Dutch captain, supported by Philippine crew members in this case. The labor inspection gave a fine for not paying the Philippine crew members the Dutch statutory minimum wage. The Philippine crew members were paid more, well, actually even less than the ILO basic minimum wage. But the question was, are they entitled to Dutch minimum wage? They were not getting it. The labor inspection fined them, and the employer said that is not correct. These seafarers are not entitled to the Dutch minimum wage, and they refuted the fine. What I do need to say also in this forum is the labor union, who is keen on protecting the labor market and ensuring that seafarers get what they are entitled to, they requested the labor inspection to fine the employer in this case. My law firm represented the labor union in question, so therefore the labor union was always playing a role in this court case. So what is important also to know is I explained already a bit about the Dutch Minimum Wage Act and what kind of act it is in the Netherlands. And I already said it has a scope rule. It sets its own territorial scope. And the scope in the Dutch Minimum Wage Act is defined as applicable to crew members on board ships that have their home port in the Netherlands. That is what is stated in the scope rule. Now, it was also, reference was made to the Maritime Labor Convention. The Maritime Labor Convention says something about minimum wages in the guidelines. And it sets the guidelines that basic wages should be no less than the amount set by the Joint Maritime Commission, or a governing body of the ILO. So it is basically a guideline, a non-binding guideline, but still it says that it should be no less. So it's a minimum standard, such as the other standards in MLC. Moreover, there was no relevant EU legislation in this case. Setting a statutory minimum wage is considered a sovereign issue in the European Union. There's no European regulation about the height of a specific minimum wage. This is considered a matter of individual member states. Then the ruling. So the employer that refuted the fine stated basically two things. One was these seafarers are not entitled to the Dutch minimum wage. They don't fall within the scope rule. Now I have to give a bit of background information because prior to this case, it was considered in general that in the maritime sector, the Dutch minimum wage did not apply. There were no previous court cases at this level, at this appellate court, regarding seafarers and the Dutch minimum wage. And basically what was argued by the employer was these Filipinos live in the Philippines, the welfare level is much lower there, and considering the goal of the Minimum Wage Act, it does not apply to these Philippine seafarers. The ruling of this appellate court was that this is not the case. It is clear in the scope rule that it applies to every ship that has a home port in the Netherlands, irrespective of where the seafarer lives. Where the seafarer lives is not a relevant aspect. That is what the appellate court said. And that is because the goal of the Minimum Wage Act is two-pronged. It is not only to ensure a certain wage standard for the seafarer, but it is also a general rule of public order to protect the employment market in terms of employment and in terms of employment conditions. Then the courts just said, well, these harbor tugs, do they fall within the scope? Do they have their home ports in the Netherlands? And all parties did agree that this home port element should be interpreted in a factual manner. So not only the flag or not only the fact that the ship owner has offices in the Netherlands is relevant. We look at the facts, and the court said we look at where does the vessel come in, where do the seafarers sign on and off, and from where is it operated, does it receive supplies? And the court said that the towage tugs operating in the Amsterdam ports have their home ports in the Netherlands, but also the harbor tugs that occasionally for a period of time operate in the UK ports still factually have their home ports in the Netherlands. So the Philippine seafarers in question should have received the minimum wage. The other argument was that the employer said, we are the Philippine manning agent, so we're not the employer. Also, if we look at Philippine law, this employer said, we are not the employer, we're only the intermediary. The Dutch court said that whether they are employer is decided in accordance with the Dutch Minimum Wage Act, and it is not relevant to look at other jurisdictions because it is decided in accordance with that Dutch act. And that according to the Dutch legislation, again, looking at the factual situation of the manning agent paying wages, planning the travel, having the contact with the seafarer and signing the seafarer employment agreement is to be considered the employer, according to Dutch law. Now, this ruling is a final ruling. There is no possibility of appeal. There is also no option that an EU court can overrule this decision because it is a sovereign issue. There is no EU principle or EU legislation at stake. Well, then what? So this case brought about a lot of commotion in the Dutch maritime industry because prior to this case, there was not such clear case law about the scope of the Dutch Minimum Wage Act. Social partners have been in contact to see whether the Dutch Minimum Wage Act should be amended to provide a clearer scope than the home port element. There is no outcome yet of this, and as of now, the Dutch Minimum Wage Act still reads the same as in this court case. Now, what is interesting, and I'm of course a Dutch lawyer only allowed to say something about Dutch law, but it is interesting to see that in Western Europe we see, well, very clear trends and developments in neighboring countries such as Norway and the UK, where basically the seafarer work that has a genuine link with the country mostly if we look at coastal work and offshore activities, are considered to be parts of the labor markets of that state. So not international shipping, but mainly shipping activities close to home. Let me put it that way. So we see that in the UK, there has been an amendment of the statutory minimum wage extending the scope to seafarers on vessels that do such work. Now, just to as a final, I think finally it's good to make some remarks. It's my job as an attorney to make some disclaimers. It's part of my job. So it is only this specific case and this set of facts, although we can, look at what the court said and see how may that play out in other cases. But it is only a ruling of the Dutch Minimum Wage Act. So it is not a ruling of other Western European countries and how they deal with this aspect. What is also important to know is that the Philippine nationality as such did not play a role in this ruling. It was about whether a worker is entitled to this minimum wage, irrespective of what nationality that seafarer has. So this ruling would just as well apply to seafarers of Indonesia or the US, I don't know, any other country. And I think it's important to underline that. Well, that was my last slide. I hope I stayed within the time, and I'm sure there are lots of questions and remarks about this case.
Yes,
thank
you, Kirsten, for you kept within time. Thank you very much for that. And more than that, actually, is that we had a clear idea of the scope of this particular case, which of course provoked the holding of this webinar. So Kirsten explained the facts of the case, and also the ruling of the Dutch court regarding the case. And at the end, of course, she mentioned just to nuance what are the limitations of that particular ruling. And of course, that brings up a host of possible questions, right, regarding does this set a precedence, okay, and how's compliance regarding that particular case. But we'll leave that to the discussion. So I think this case will provoke a exciting discussion for today. So any questions can just be placed on the chat. Although I also see a Q&A, so there are two alternatives actually. You can post your questions on the Q&A and also on the chat. But we'll have time for that later. For now, we'll ask our reactors to also give their inputs. So for our first reactor would be Attorney Generic Humphrey Morales, okay, or just Genic, if I got it right. So Attorney Genic is a National Vice President for Operations of the Association of the Philippine Seafarers Union, which is part of the Associated Labor Unions. It is also an affiliate of the International Transport Workers Federation. Attorney Genic is a consultant on seafarers and overseas matters with the Trade Union Congress of the Philippines and the TUCP party list. He started out his career as a maritime lawyer. Of course, he's a member of the Integrated Bar of the Philippines. So let me call on Attorney Genic. You have the floor.
Thank you for the wonderful introduction, Professor Velasco. And thank you as well for the invitation to my esteemed Professor, Dr. Amante, for this opportunity to share some knowledge with regard to the topic for today's forum. I guess we have to start on laying the predicate on who is to be considered as an employer of the seafarer. I believe this Kirsten already touched upon this during her discussion, but I want to focus on the Philippine setting based on our laws and based on the rules of other government agencies. As we all know, a seafarer applies or is being recruited by a licensed manning agency. So under our law, a licensed manning agency is an organization or a corporation, a partnership duly licensed by the appropriate government agency to engage in the recruitment and placement of seafarers plying international waters for maritime activities. So with this, who is considered as the direct or who is considered as the real employer of the seafarers? Under our law and the rules, the principal is to be considered as the employer of the seafarer as defined under our rules. A principal is an employer engaging and employing seafarers through a licensed manning agency. So in this case, who is the principal employer or who is really the employer of the seafarers? So it should be the Dutch corporation or the Dutch organization. This is a very interesting issue because it creates a problem in international law. So as we call it, we will have conflicts of law. However, I find it with the discussion of Kirsten, I do not find any issue, as it turned out it was favorable to the seafarer. So I guess regardless of whoever is the principal or whoever is the employer of the seafarer, he or she would be able to get the minimum wage as based on the legislation of the Dutch law. As well as touching on the topic of the ILO minimum wage or the IMO or the ITF minimum wage, this only sets the bar as the minimum for the wages of the seafarers. As mentioned earlier, who is the employer of the seafarers? Then the employer of these seafarers are the foreign organizations found in other jurisdictions. So like land-based or sea-based, wherever a particular Philippine or overseas Filipino worker is found, the minimum wage of a particular jurisdiction should be followed. So I believe that the ruling of the Dutch courts is in consonance with this principle in international law or in terms of labor and wages. I have also noticed some questions or questions that were sent prior to this forum regarding seafarers and CBA. Again, this is in relation to the minimum wage. So a collective bargaining agreement is a negotiated contract or a negotiated agreement between different parties. But again, we need to go back on the minimum wage as this sets the minimum standards of the wages to be given to seafarers. So regardless of your CBAs or regardless of territorial jurisdiction and where the overseas Filipino workers are found, it is I think it would be in the better position that that the minimum wage of a particular country should be followed. So that is my short reaction or short discussion in connection with what Kirsten has discussed earlier, and I would be glad to answer some questions during the question and answer portion.
Thank you very much, Attorney Jenick, for that intervention. So Attorney Jenick mentioned that as far as Philippine law is concerned, okay, overseas Filipino workers are guaranteed minimum wages according to the laws of the destination country. So in this case, it appears that there is no conflict between what's mandated by Philippine law and the decision of the the Dutch court regarding this particular case. So yes, so that's one point of view about the implications for Philippine seafarers of this interesting case in the Netherlands. Let me see, I'm just checking. So yeah, next we'll call on Attorney Captain Jean, but let me introduce Captain Juanito Salvatierra, or just Captain Jean for his friends, is the present chairman of the Joint Manning Group, or JMG. JMG is an umbrella organization of the 5 major associations in the Philippines. He is also current president of the Philippine Association of Manning Agencies and Ship Managers Incorporated, also of the International Maritime Association of the Philippines. He is also part of the board of directors of the Philippine-Japan Manning Consultative Council, all of which are under the JMG. Additionally, Captain Jean is a member of the board of trustees at Bagong Bayani Foundation Incorporated, a director and vice president for external affairs of the Society of Filipino Ship Captains and the PMMA Alumni Association. He is also a former member of the Maritime Training Council for the private sector. After completing a degree in Bachelor of Science in Maritime Transport, major in navigation and seamanship in 1967, Captain Jean started working his way to become a full-fledged shipmaster in 1987. He has also held and holds executive positions in several other manning agencies. Presently, he is president of PIMCO Ship Management Corporation and Tara Trading Ship Management Incorporated. So let us welcome Captain Jean. You have the floor.
Thank you, Professor Benji Velasco. A pleasant good afternoon to everyone present in this forum. Firstly, I would like to acknowledge and thank the UP School of Labor and Industrial Relations for the invitation to take part in this very important forum as one of the panel speakers. You are correct, Sir Velasco, in saying that the JMG is or the Joint Manning Group is an umbrella of 5 different major manning associations in the country, namely the Filipino Association of Mariners Employment, or FAME, the Filipino Ship Owners Association, or FSA, the Philippine Association of Manning Agencies and Ship Managers, or PAMAS, the International Maritime Association of the Philippines, or INTERMAP, and lastly, the Philippine-Japan Manning Consultative Council, or PJMCC. Collectively, the Joint Manning Group represents about 80% of the manning companies in the Philippines and employs some 400,000 Filipino shippers on board ocean-going vessels, providing human resources and other maritime-related services to ship owners around the world. This representation converts to more than 6 billion in foreign exchange earnings annually in terms of crew salaries, and other related operational needs. Now, to start off my comments, allow me to give you a brief overview of the Philippine mining and seafaring industry in the Philippines. The Philippine mining and seafaring industry developed together with the growth of the international economic activities. And for more than half a century, this particular industry continues to grow with the collaboration of the local mining agents, the ship owners, the foreign ship owners, and the ship managers. Given the vast Philippine coastline as an archipelagic state, which is double the coastline of the United States, and nearly 3 times the coastline more than China, the Filipino then had natural maritime instinct that placed them at an advantage over other nationalities. Currently, apart from those well-sought qualities and traits of the seafarers, which are communication skills, adaptation and flexibilities, dedication, discipline, problem-solving ability, and law-abiding characteristics. Thus, the Philippines became the leading supplier of seafarers for the international shipping community. It was in the 60s and moving on to the 70s when the Filipino migration started in view of the international development, and business sought for cuts in expenses from countries like the United States, Germany, the Netherlands, Greece, and other European countries. The same period when agencies rose up to seemingly aid those wanting to work abroad and on board. Greece is one of the primary countries who tried the Filipino seafarers to man their growing fleet. And as this activity grew, the Philippine government established the National Seamen's Board in 1974 to look after the overseas seafarers and regulate the recruitment agencies. It was different then, since only a seaman book facilitates the crew, the Filipino crew, to travel, as this also served as his passport. In 1974, under Presidential Decree 474, Marina was created to regulate the domestic shipping, shipbuilding, and also crew training. Presently, after 5 decades of government supervision of the Filipino seafarers and mining agencies, we are now in the case of the new, they are now in the care of the newly created department to regulate and oversee the welfare of land-based and sea-based workers. It is the Department of Migrant Workers. Now, for those of you in this forum who are not familiar on how the Filipino seafarers obtains employment on board ocean-going vessels, please allow me to walk you through the process. Firstly, the licensed mining agent, through his business acumen, networking, by referrals and other means, he somehow managed to establish the trust of the ship owner. And so the ship owner appoint the licensed mining agency to recruit and provide the required officers and crew for their vessels. The mining agency then gather all the documents required by the POEA, which is the Philippine Overseas Employment Administration, to enroll the ship owner as its principal of the local mining agent. Among the important documents that is presented to the POEA for the verification of the Filipino crew's employment are, firstly, the mining agency agreement. This agreement specifies the duties and responsibilities of both the principal and the mining agent in accordance with MLC, or the Maritime Labor Convention. Number 2, appointment letter. This document states the number of crew required on board the ship, specific ranks, positions on board the vessel. And lastly, and most importantly, salary scale or wage scale for its crew. So these documents, these 3 things are submitted to the POA for evaluation, and certainly all these documents and declarations submitted to POA are already, we presume, are agreed between the manning agency and the principal, specifically the wages. The wages can be minimum benchmark of ILO or what the CBA dictates, or what is the minimum salary of that specific flag state that the vessel carry. So it is actually decided by the CBA, the country of registered vessel, and if there is no CBA, then the minimum ILO. When these documents are verified and accepted by POEA, the POEA then issued accreditation certificate to the principal. And with such valid accreditation, the manning agency can now recruit qualified officers and signs contract of employment with the seafarers on behalf of the principal. The Filipino seafarer, then having a valid contract, is then issued an OEC, or an Overseas Employment Certificate. This certificate is a necessary document to pass through the Philippine airports so that they can depart Manila to join their ships. All these documents, documentation and transport arrangement are done by the manning agency as his responsibility under the manning agency agreement. I hope you're able to follow the flow procedures, how a seafarer is deployed on board. These strict documentations procedure for deployment of seafarers were established by POEA in consultation with the manning industry to prevent the so-called illegal recruitment by some scrupulous individuals exploiting Filipino seafarers. But really, mind you, being in the business, nowadays this illegal recruitment no longer exists in our industry. With such established procedure for determining on how much will the seafarer's salaries to be paid on board, I find it intriguing in the statement on the decision of the copy of the Dutch court presented to us in this forum, where the appellant manning agency, or the appellant Philippine manning agency, was fined 43,800 euros. The decision reads, the fine report states that the investigation by the Inspectorate SCW has shown that the Filipino crew members mentioned in this fine report were employed as crew members and performed seafarer services on board 7 ships that sail under Dutch flag, are registered in the Netherlands, and have Dutch home port. The fine report states that the administrative investigation revealed that the 9 of the investigated Philippine crew were underpaid, which is a violation of Article 7, first paragraph. Let me clarify that under the Philippine law, the seafarers are supposed to withhold at least 80% of their basic salary to be remitted by the manning agents to their nominated receivers in the Philippines, and the rest of his wages he can now collect on board. It is then the master of the ship, hired by the principal, who is supposed to pay the balance of the crew's salary on board. So how come the Filipino seafarers were underpaid? I see 2 scenarios that lead to such underpayment. 1, the manning agent did not do his homework on salary negotiation with the Dutch owners on the correct wage scale to implement on board their Dutch flag vessel. Number 2, second scenario, the Dutch owners, as the real employers, should have known their labor rules regarding seafarers' compensation on Dutch flag operating on Dutch territory, and should have given proper instruction to the master. But perhaps this ship owner decided to disallow the payment of holiday allowance and other benefits to the Filipino seafarers to save cost. As I understand it, it is not only the Netherlands that implements their country's own salary scales for foreign seafarers working on board vessels operating continuously on their shores and territory. Australia is one country who enforced ship owners to pay foreign seafarers the Australian wage tariff for seafarers, which is way over and above the negotiated contract when they joined ship. If their vessel is trading in Australian ports for 2 consecutive voyages, where the ship would load from one Australian port and will discharge the cargo to another Australian port, then these foreign seafarers are bound to be paid at the Australian minimum wages. Actually, we have one of our manned vessels in that kind of trade since September under BIMCO Ship Management, my company. And our Filipino crew on board are very happy to receive additional compensation over and above their agreed wages in their contract. So finally, we at the Joint Manning Group maintains our advocacy to find the best possible and most agreeable agreements and benefits for our seafarers, while seeking a healthy balance of providing the most efficient and economical service to the ship owners. The Filipino seafarers, generally coming from below middle class families, will be happy to receive European wages or ILO wages, for that matter, as negotiated by the local manning agents with the ship owners and as approved by the POA. As long as he has the assurance of job security and sustainability to feed his family and to be able to improve his well-being, I believe he will be an asset, a hard-working crew to the company that he is working for. And I would like to end to say that the member companies of the JMG are doing its part to nurture the mining industry that we have established for more than 50 years by complying with the existing rules and regulations and conventions like the Maritime Labor Conventions, employing Filipinos with no less than the ILO minimum wage scale, and by making the Filipino seafarer stand out. I hope the government will now continue to attract foreign ship owners to hire more Filipino seafarers by making it easy to do business in the Philippines and maintain our position in the IMO's whitelist in order that we can retain our position, the Filipino seafarers, as the #1 seafarers of choice. Thank you so much, everyone, and mabuhay.
Yes, maraming salamat. Thank you very much, Captain Jean, for describing the lay of the land as far as the industry of manning and shipping in the Philippines. Also for a short description on how the deployment of Filipino seafarers have started and evolved through the decades. He also shared the fact that it's not just in the Netherlands, for example, where local minimum wages are being implemented for Filipino seafarers. He mentioned Australia, as one particular country. And also, I guess, very important that Captain Jean gave his own analysis of probably what happened to this particular case. That how did it happen that Filipino seafarers in those towage ships were paid below the Dutch minimum wage. So I guess that's a good start. I guess a good starting point for discussing further this issue. So Professor Mante, do you see any of our reactors?
Yes,
None. I see none, right? Yeah. So I guess we can proceed to the open forum. But before that, maybe I can ask Kirsten if after hearing Attorney Jenik and Captain Jean, if she would like to give some brief remarks, and then we proceed to the open forum.
Well, very interesting to hear all the different comments about the ruling. Also interesting to hear the proceedings regarding manning agents. I think what is important to note is that in the Netherlands, the discussion is centered more around what is the scope in terms of what seafarers fall under Dutch Minimum Wage Act and who don't. And I think in the maritime sector, and as I hear here, the second part of the ruling is also very interesting, where the manning agent is considered the employer in terms of Dutch law. So I just noted that, and I'm interested to hear more comments. Yes, I will leave it to that for now, I think.
Yeah, so with that, thank you again, Kirsten. And with that, we can entertain questions from our webinar participants. So can our participants? Yes, Professor
we acknowledge the presence of our Dean, Ronali Asuncion is here, and our esteemed colleague from the University of the Philippine College of Law, Professor Pat Daway, is also here. We also have Arvin Peralta from the OWA, so maybe we could invite Arvin to also speak. And also we have I was surprised, we have a representative from the Overseas Workers Welfare Association. I'm sorry that I think Francis, Assistant Secretary, could not join us because maybe he has difficulties. Also, Attorney Partido from the AMOSOP is in another island, which is now experiencing heavy pounding from rains. That's the message I got. So maybe they have difficulty. Yes, from the OWA is Gaylord Caronan. So maybe if we could also speak something, say something in behalf of the government. We have a message here from Arvin, the ITF inspector presenting. Oh, so maybe Arvin, in behalf of the legal head, the head of the legal office of your union, the Associated Marine Officers and Seamen's Union of the Philippines. I hope I got that right. Arvin, are you online? Maybe Professor Benji, on behalf of the AMOSOP, we could ask Arvin to speak because he also attended the MLC webinar with us, right? Arvin, could you like to open your video and say a few words to comment on our topic? Are you available, Arvin?
Hi po. Am I clear? I'm currently on the road.
Yes, we could hear you.
Hello?
Maybe the car is moving, so maybe, but please go ahead.
Yeah. Good day to everyone. I'm currently on the road, and I was able to catch up with the forum. Interesting topics being discussed right now. For the ITF, International Transport Workers Federation, and with AMOSOP, we try to find the best agreement in benefit of the seafarers, and we always work with the stakeholders, with the affiliated unions and the principals of the vessels covering the vessels to follow ITF standards in relations to the basis of ILO minimum wage scale. And we are working hand in hand with other affiliated unions, and especially with POAID and now the DMW, with regards to contracts, CBAs, wage scales, and to promote better working and living conditions and welfare services for our Filipinos.
Thank you for that statement. Ben, would you like to go ahead with the Q&A?
Yes,
Some,
yes, we have already several questions that I see on the chat. One is, I guess this is for Kirsten. There's an appeal is possible at the EU Court of Human Rights, a procedure against unfair trial.
Yes, I think that's from one of the colleagues, or maybe a crewing agency employer.
Yes, would you like to comment, Kirsten?
Well, of course, if in case there is an unfair trial, of course, there's always an option to go to your European Court of Human Rights. I think in this specific case, that would not be an option since all the different instances have been tried before, and it was a very extensive trial proceedings, I think on behalf of the employer, the Chamber, the Royal Association of Dutch Ship Owners also participated and included an expert opinion for their position. So, well, that is my humble opinion. Unfair trial is not at issue here. But
Yes,
technically,
it
is an option in case there is an unfair trial.
Yes, thank you, Kirsten, for that perspective. Another question, the question is, what is the stand of the ITF, or the International Transport Workers Federation, with regards to minimum wages? We don't have a speaker from the ITF, but maybe Attorney Jenik, because APSU is an ITF affiliate. Maybe you could respond to this. What is the stand of the ITF with regards to minimum wages?
Arvin is from ITF, so I work with Arvin a lot. In fact, I work with I can see familiar names and faces here in the forum. This is not an opinion of ITF. If you ask about the opinion of ITF, but as per what we are working with ITF is, we always see to it that all CBAs are at par or above the minimum standards or the minimum wage set by the ILO. Again, as mentioned earlier, CBAs are negotiated contracts or documents that we ought to negotiate with the principals or the ship owners, and with other stakeholders as well. So I guess what ITF follows is the ILO minimum wage, based on what we agree upon every year or every 2 years. So that's, I think that is what ITF follows.
Yeah, thank you, Attorney Jenik, for that clarification. We also have another question, but before I read it, let me say that for our participants, if you would like to speak, to ask a question, you can raise your hand, and then I'll just give you priority. But those for others, you may still, as I mentioned earlier, post on the chat or the Q&A. And we have this question at the Q&A from our colleague, Dr. Rebecca Gadi. Her question is, how can we avoid this lapse in the future so that we lost the question, Brian. So I see it now. How
From
can we avoid
Benji.
this lapse in the future so that our seafarers will not suffer below legitimate wages abroad? Maybe not just in seafaring, but also in other industries as well.
Prof. Benji.
Maybe, yes, Prof. Amante.
Captain Jeans already answered us very clear on the answer to that, right? Captain Salvatierra already responded to that very well. Huh? Because first of all, yes, it's mainly a question between the shipping crewing agent and the employer to do the job. That's the essence of what Captain Salvatierra said.
Yeah. Thank you for Prof. Amante for that heads up.
There's another question from Joe.
Yeah,
Cato.
Prof. Amante. I don't see that. Sige, maybe you can read
I don't
it,
know why,
Prof.
but
Amante.
it is in the chat. And maybe Lynn Bacani may also have some other questions. But I could read the question to Kirsten. The ILO gives a suggested benchmark rate for the AB only. How do you compute for the minimum wage of the other ranks in the other vessels? I don't know if Kirsten could respond to this. And I also noticed that
Just to make clear in this forum that the court case was only about the Dutch minimum wage, and the Dutch Minimum Wage Act only has one amount, irrespective of what position you fulfill, because it is a minimum wage that applies to every employee in the Netherlands. So there is no difference between what a captain or an AB or a first officer or whatever is entitled to as a minimum. Now, what I know, but I think there are other people in this forum that can better answer this question, is that the ILO gives the AB rate, and I think the ITF and IMO together make this schedule. I think we all know this one pager with the different ranks where it is benchmarked basically from the ILO AB rate. But in the court case, this was not relevant because it was ruled that the Dutch minimum wage applied. And just maybe as a side fact, in the court case, from the employer side, a lot of reference was made to CBAs, to the ILO minimum wage, but the court said it doesn't make a difference what other rules apply because the Dutch Minimum Wage Act supersedes these minimum standards. So that is not relevant. And in the case, actually, even the ILO minimum wage was not paid to these Philippine seafarers. I think there is another question, if I may, if I now have the floor, is that somebody asks, when does the minimum wage start to apply for foreign seafarers engaged to work on Dutch ships operating in Dutch territory, from the day they depart or from the day they sign on board the ship? From a Dutch Minimum Wage Act perspective, the Dutch minimum wage applies to the whole employment agreement. So if a seafarer works for 6 months on a Dutch project, on a vessel that has a home port in the Netherlands, it would apply to the whole employment agreement. But I do know that in practice also the seafarer unions are struggling to see how this works out in practice.
Thank you, Kirsten, for that. Do you see another question, Prof. Amante?
May I, Prof? Prof.
Yes,
Amante.
Lynn.
Yeah, I would like to read the question from Assistant Professor Ben. Okay, actually, this is your question. I would like to ask what next steps have been done after the Dutch court decision? Any info about compliance with this decision? I think this is important to clarify. What's the status?
So maybe it's addressed to
So-
Kirsten, right?
Kirsten, yes.
Yes. Well, the Minister of Infrastructure and Water has made several statements that social partners are discussing whether to amend the Dutch Minimum Wage Act to provide for a clearer scope. He also has clarified that in case of international trade, the Dutch Minimum Wage Act would not apply. Such statements do not amend, the statements of a single minister do not amend the Dutch Minimum Wage Act. So I think in the maritime sector, people are waiting to see what amendments will be made with respect to the scope. The other thing I see in my practice, aside from this ruling, is that especially in more offshore-based projects, ship owners are aware of this case and they want to make sure they are compliant, which is very important. And they just pay the extra minimum wage. And I see that this already happens in the early stages of contracting, so that the extra costs that they have, they can include in their bid to participate for a certain work. So you already see that in practice, ship owners or contractors take cognizance of this ruling and act upon it to be sure to be compliant. At least that's what I see in my practice.
Thank you, Kirsten. Attorney Jenny, you have an intervention. Yeah.
Yes, just a follow-up on the question from Professor Lin to Kirsten. I believe what Kirsten had said was more on what they're going to do in the future, but is there anything in particular from the ruling or from your rules in your country that certain back wages of the differences from a particular period will be awarded to those seafarers?
Sorry, can you repeat? I do not fully understand the question. Can you explain?
Yes,
Again?
if as the Dutch law has ruled that what the seafarers has been paid are much lower than the minimum wage under the Dutch law, is there a part of the ruling that they need to be paid for any back wages or for any difference for a particular period prior to
Yes.
the date of the Dutch law?
So the court case, the labor inspection takes two measures. First is that the back wages need to be paid, which they were, to my understanding, in this case. And then the second part is that they get an extra fine, a punitive fine, for a violation of the act. And in the court case, the employer refuted the fine.
Thank you, Kirsten.
Yeah. So I see a raised hand from Christine Bader. So
from the ILO. Yes, he's from the
I'm
ILO.
going to
Welcome.
ask.
Yes.
Yes, hello.
Yes. Welcome from the ILO.
Hello, everybody. This
Yes,
is
welcome.
really interesting, and I'm happy to be here. Good to see you again, Kirsten. Just from an ILO perspective, of course, the ILO minimum wage is a recommendation. It is recommended by the MLC. And it is important actually for all ranks, even if it's only for the able seafarers, it has been said correctly, but it is important for all ranks because it will be then, you know, as Kirsten said, it will be then just adapted to the other ranks according to this schedule. And it is important actually for all member states, even for member states where the minimum wage is much higher, because it is being used then at the national level as in the negotiations, just to say, hello, look at the ILO, it has been raised, so we expect here the same thing. So just to say that, and of course you can always go beyond. The ILO minimum wage is a universal minimum wage. It is a recommendation, and you can always provide more favorable working conditions. That is always has been the stand of the ILO. You can always, provide more favorable conditions than the minimum universal standard. And so I have two questions, quite speculative for Kirsten, but let's see whether. So you have said that the home port was the criterion, the main criterion for the ruling, because it provided the genuine link, and that not only, that was your words, not only the flag state counted here. Now, theoretically, what do you think would have been the decision if the flag state had been not Dutch? Everything else is the same. But if the flag state had not been Dutch, but the home port is still, everything else is, So that is one question. And then two, you said that the law might be amended or in the future, because it's being discussed after a lot of commotion. Is there a possibility that it will be diluted again, so that this is not, that the home port is becoming less important, just according to your estimation? Thank you.
Thank you, Christine from the ILO. So 2 questions addressed to Kirsten. Speculative, as was mentioned. So would you like to speculate?
Always tricky. Yes. Well, first, what is not speculation is what Christine already underlined, and I completely agree. What I see also in the discussion is that the ILO minimum recommendation is used basically to set the standards, but it is not the standard. It's the basic bottom minimum recommendation. So I'm happy with the comments from Christine on behalf of the ILO in that respect. So there were 2 questions, hypothetical, and it's very tricky for me to answer them. I'm not, I don't have the authority, of course, to rule. But as I read the judgment regarding the first question, what we see over time, basically in the last maybe 20 years or so, is that the flag as an aspect to decide what labor condition applies is of lesser importance, because seafarers also, when stipulating their employment condition, have no real power with respect to the flag. Moreover, a ship can reflag even during an employment. So the flag, I think, if we look at the trends also in other maritime employment cases and in legislation, has become of lesser importance. Well, that is basically my step up for the answer of your question. I think if the facts were exactly the same, but there was a different flag, the Dutch Minimum Wage Act in this case would still apply, because these ships were, well, they factually had their home port in the Netherlands. But of course, that's only speculation. But we have to take into account that the criterion of home port is flag blind in the Dutch Minimum Wage Act. And the second question was regarding the amendments. So I think it is important to note that the trend in whole Western Europe is that we do much more in our offshore, in the continental shelf, in our exclusive economic zone, so even beyond our territorial seas. These are projects that are funded mostly by the coastal state, with lots of money from the national governments. and it is considered, I mean, we can basically look at it from the coast and see the work being done on windmill parks, on pipe laying, on offshore projects. And I think that is the trend that will also be important when amending the Dutch Minimum Wage Act, that there will be a clearer scope in that respect, because that work at the sea in the continental shelf is regarded more and more as of national importance. And there are some stakeholders also from the government that say we cannot allow using government funds and then have non-EU workers working there for a third or a fourth of a Dutch minimum wage. That is not right. Everybody, irrespective of their nationality, should receive the same amount of wages. But this is more speculative and political, of course, very political sensitive debate.
Yes, thank you, Kirsten, for those responses. There's a question here asking about why is our forum titled Implications for the MLC 2006? But I think it should not be addressed to Kirsten, because this forum was actually a brainchild of colleagues at the University of the Philippines School of Labor. So maybe I can ask Prof. Noy if you have a brief remark about the title of our forum. Why does it have a tagline, Implications for the MLC?
Yes, very good. Actually, I'm trying to find out if our Department of Migrant Workers Assistant Secretary could respond to some of the questions online, because I think he has difficulty in logging in. So in a way, it is, we have an office, before it was the POEA, now it's called the Department of Migrant Workers, and we have an Assistant Secretary who is supposed to be here, Attorney Francis Rondi Guzman, who is certifying compliance with the MLC, Maritime Labor Convention 2006, including minimum wage. So how is that being done? I would like to know more details. So that is in fact the reason why we would like to hear from him. So I posed the question to him. Maybe he could respond later. But what are the implications? You see, we ratified, the Philippines ratified the MLC 2006 convention. A lot of course, discussions. I saw that. 2012. Now it's 2022, 10 years later. We have a lot of law students here. We have law practitioners. And as you could see, we have lots of litigation. We have lots of court cases involving money claims and disability claims, etc. in our lower courts, and in the Supreme Court itself, we have lots of seafarer cases. But part of that are a payment of disability claims as well as monetary claims. So that would be the implication there that is very specific. But Captain Salvatierra already mentioned the steps forward. You see, the Philippines is still a significant supplier of the global seafarers all over the world. Whether EMSA audit or not, whether IMO whitelist or not, we are still going to see, because according to Captain Salvatierra, that is our nature. But of course, that's a brief answer. That's a long answer, but the implications are we really need to work on it. We really need to do our job as not just as a maritime stakeholder, but we in academia should really study this, because number one, the MLC, I still have to find a case in the Supreme Court decision that mentions the reference to the Maritime Labor Convention. I think I could stop there. Joe Cato, I think, thank you very much for your question. But Christine Bader from the ILO, I already answered a lot of your question. Thank you. I end there.
So yeah, thank you, Prof. Amante, for that clarification. I see.
Velasco, may I?
Yes, Lynn.
Yes, sir. I believe in relation to our main topic, we can also discuss about the taxation scheme for Dutch seafarers, because our OFWs, of course, including the seafarers, are enjoying tax-free from their income.
What's the question, Lynn?
About the taxation scheme for Dutch seafarers, compared to our Filipino seafarers who are enjoying tax-free from their income.
So your question is to Kirsten, of course.
Yes.
Whether we also deduct withholding or income taxes from everyone in the Netherlands, including seafarers, foreign seafarers. Kirsten, could you like to respond to that?
Yes, so this was also brought forward, and it's a good point. The Dutch Minimum Wage Act takes as a starting point the gross wages. So whether, there are many varieties from a fiscal aspect of what amount of wages are paid or not. And if you are basically set free from wages, it is still considered that you live in a country where you have to pay for different aspects that some seafarers do have to pay taxes for and some don't. So the Dutch Minimum Wage Act takes gross wages and not net wages. And it is explicit. I think the reason behind it is that all seafarers and international employees have all different kind of taxation schemes. But it is important that the gross wages are set at a specific level from a Dutch government point of view.
Is Mr. Arvin Peralta still online? Maybe he can answer this question from Second Engineer Christopher Boha. Regarding Filipino seafarer working in UK offshore, we are paying tax here and national insurance despite the law in the Philippines that OFW is tax-free from our income. And this year, they cut our tax allowance, as well as because they said OFWs are not considered a citizen of the Philippines when under contract outside the country. But what is our residency now if we are not citizen of our own country? How can the Philippine government help us with this matter? This is about taxation also.
Lynn, you are calling Arvin. I think Arvin is available. Arvin, please go ahead.
Arvin Peralta, yes, this is a question about taxation.
I was just chatting. I was planning to say, can I share my thoughts? And there's a new question now. About the seafarers in UK, we should know if this they are on board national flag vessels or flag of convenience vessels. Flag of convenience vessels, like the topic now of Dutch vessels owned by Dutch principals or owners and or owners that are registered in Netherlands flag in the Netherlands. Those are classified as national flags. Flag of convenience vessels are vessels which vessel owners or principals nationality is different from where the vessels are registered. And the ITF inspectorate is more focused on flag of convenience vessels because these vessels have lower standards of wages, welfare benefits, and rights stipulated in their minimum standard terms and conditions. That's why this is where unions are negotiating collective bargaining agreement to vessel owners of these flag of convenience vessels to cover their vessels, to increase their benefits with regards to wages and welfare principles that are included in the agreement, which supersedes what's written in the POA standard terms and conditions. With regards to the question of the second engineer that was raised earlier, we should know if it's a national flag vessel or flag of convenience vessel, and if they are direct hire or they pass through POA POA or they have POA contracts. Because if they have POA contracts, they supposedly Filipinos will not be charged of tax. But in their case, they were charged of tax. Most probably, they are direct hire or under national flag vessels, in which the standards of the national flag applies to them. And with regards to the POA minimum wages, I have raised this concern recently to POA. They say, yes, we have the ILO recommended rate. However, our guide, we refer it to current market rates that we observe, and also based on the industry rates. But unfortunately, our benchmark in the POA is still 465 USD, and it's already a decade already. That's why, what Kristen is discussing, that the Netherlands are having their minimum standard. The Philippine minimum standards is already decade and needs to be updated in relations to the ILO recommended standard of $642, if I'm not mistaken. With regards to what was discussed before, it's all about cabotage laws, and the good cabotage law is yes, it was being it was discussed earlier about the Australia Fair Work Act, and I hope I was able to answer the question, and thank you for addressing it to me.
Yeah, thank you, Arvin. I think Attorney Jenick has some inputs.
Yes, I just want to briefly discuss regarding the taxation. As a general rule under our National Internal Revenue Code, any income of a Filipino citizen derived here in the here or outside the Philippines are subject to income tax. However, there's a Bureau of Internal Revenue regulation. I think it's 1-2011 as amended by Revenue Regulation 12-2012 that overseas Filipino workers are exempt from income taxes. So overseas Filipino workers, including seafarers, are exempt from taxes. Again, this is where the jurisdictional law of other state applies. So if you are working on a different jurisdiction or another state, their home law or their income in terms of taxation law may apply to you. That is the reason. It is one of the principles of tax reciprocity. If the foreign jurisdiction already apply income tax to the particular overseas Filipino worker, that is the reason why that the Philippines does not apply income tax as well to our overseas Filipino workers. However, of course, if the OFW has other businesses here in the Philippines or other sources of income, of course, that will be subject to income tax. So whatever is being derived here in the Philippines will be subject to income tax. So what is only exempted are the income earnings of the overseas Filipino workers abroad.
Yeah, thank you, Attorney Jenick. So I guess that's to prevent double taxation, right? So that the BIR exempts OFWs from the Philippine income taxes. Do you see any other questions, Lynn?
This is okay. It's good.
Maybe a quick one for Kirsten. There's a comment that your statement that the ILO minimum wages was not paid is not correct. Any comment about that? Also, the conclusion that the manning agent is considered an employer by the Dutch judges still, in my opinion, puts the manning agent in a difficult spot since they cannot control the movements of the vessel, and yet they are exposed to the fine. The principle of the minimum wage is not the issue. It is how to monitor from the Philippines. Any comments about, any reactions about these comments? Kirsten.
Well, firstly, I've seen the Seafarer employment agreements when
For this particular case.
Yes, so, and it was below, the basic wages were below the ILO minimum wage at that moment, but I don't think that's too relevant with respect to the case, because it's not a case about ILO minimum wage, but the Dutch Minimum Wage Act, of course. But the second point raised, I think, is very relevant, that, of course, the manning agent is in a difficult position because he's not the one in charge of the vessel and where it goes. What we see in practice is there is, of course, an agreement between the manning agent and the principal. And we also see that not in the seafarer world, but in other international constructions in the Netherlands where the Dutch Minimum Wage Act applies. The manning agent never has the authority to decide about the work because the manning agent is just not there. But it is already, clauses are included in the contract that states if the Dutch Minimum Wage Act applies, then the ship owner will pay Dutch Minimum Wage Act, or that if in case of fine or there would be back wages need to be paid, the ship owner needs to pay for that. That's one part over the contract, and I see that already happening in practice. On the other hand, we see that even on a much earlier stage, even before the manning agent is involved, the ship owner for specific projects investigates what laws are applicable, such as Captain Jin already stated in his remarks. That we see ship owners taking responsibilities to investigate themselves what they need to do in terms of compliance, and to make sure that the workers that they hire from a manning agent get what they deserve. Also, because if we look at the Dutch legislation in a broader perspective, and also in the Maritime Labor Convention, there are specific responsibilities for the ship owners that they have. I think there it is true that it is a difficult position because a manning agent does not decide about where a vessel goes. But I think there are ways, by terms of an agreement, in the agreement with the ship owner, to address these risks for the manning agent.
Yeah, thank you, Kirsten, for that response. Captain Jean has a question or an intervention. Yeah.
Yes, this is a intervention or a
yes, go ahead.
Comment from Mr. Cornelis Johnson. I fully agree with you on behalf of the JMG. You see, the POAA has this rules governing the employment of Filipino seafarers, and these rules is different from the land-based rules. Now, under the rules governing the employment of the Filipino seafarers, the POAA dictates that the owners and the manning agents are jointly and severally liable for all the obligations related to the seafarer, meaning salaries, benefits, and the like. Now, these rules is now under revision and amendments because we have been, the manning industry has been clamoring a demand to the POAA, now the Department of Migrant Workers, to review these governing rules covering our manning industry. In the management, in the Maritime Labor Convention, there are two different descriptions for ship owner and recruitment agencies, correct? Can anyone disagree with me? There is a definition for ship owner and a definition for the recruitment agencies. So where are we? Why are we being called employer? Now, also in the MLC, there is that definitive responsibility as per MLC amendment recently. The financial responsibility of the ship owner is enshrined in Regulation 4.2, which is payment of salaries in case of bankruptcy, and Regulation 2.5, which is payment assuring the medical benefits of the seafarers in case of accidents, illness. These are responsibilities of the ship owner. Now, where does this manning agency come from? Why are we being jointly and severally liable to pay for this? When the ship owner gets bankrupt, we pay for the salaries. So we are asking our government to review this. We are just service providers, the manning agencies. We all get our money from the ship owners to pay the crew, to give them the transportation and everything. We are just service providers. But in the eyes of the DMW or the Department of Migrant Workers, we are one with the ship owner. So thank you, Mr. Cornelis Johnson, for viewing on the same level with us. Thank you.
Yes, thank you, Attorney. Sorry, Captain Jean, for that input regarding the problem being faced by manning agencies. Unfortunately, we don't have anyone from the DMW to respond appropriately. Although, I guess just from an IR, industrial relations perspective, I guess the issue, the principle of joint and several liability comes from the fact that there must be somebody to be responsible when workers are not paid their wages. So yeah, but of course that brings up a lot of issues, right, on who will take responsibility for that. So yeah, Lynn is
Sir Velasco,
Attorney Jean.
Sir Velasco, if I may, it is enshrined in MLC. The ship owner pays for the wages. Ship owners pays for the transportation when seafarers are disembarked for whatever reason, illness, accidents, and it also they pay for in case of piracy when they are being under the kidnapping situation. So as I've said, the money agencies does not have a place for this now because the MLC dictates it is the ship owner's responsibility, not the money agent. So our rules are contradictory to the MLC. I'm sorry.
Yeah, the principle of joint and several liability is a local. Yeah, it's a Philippine labor law provision. So, Lynn, do you still have one question?
Yes, yeah. I believe this is a good way to end the forum with this question from our pre-registered participant joining from Belgium, representing the Mission to Seafarers and Sea Network. His question, June Mark Yanes. The question is from June Mark Yanes. How does this particular case uplift or affect our seafarers in general? Maybe hear all from our speakers.
Yeah, maybe Lynn, we could add one other question that has not been addressed.
Yes, okay.
I don't know if Eloy Calimoso, also maritime media, is still here, but he was the one who asked this question. Eloy is still here, but I think he was asking what with this Dutch decision, will it make the Filipino seafarers more expensive? But I think Kirsten already answered that question. Huh? Okay, so please go ahead. Who is going to answer that question? What is the future with respect to seafarer welfare, which everyone could address, or all the speakers could address? Kirsten, Captain Salvatierra, and Jenny. What's the future for Philippine global seafarers? Not just Philippines, no? Maybe all global seafarers in the future, because we have agreed to a Maritime Labor Convention. So therefore, we have to do our best to implement or to comply with the provisions. Of course, our courts and a lot of Supreme Court decisions have recognized and established the principle of solidarity, jointly liability between the crewing agent and the ship owner. So we got years of Supreme Court jurisprudence in that regard. So of course, that's a important principle that will guide maybe our answer.
Yeah, Prof. Amante, Captain Jean has would like to respond.
Yeah, please go ahead, Captain Jean.
Yes, thank you, Prof. Amante. Presently, there are about 1.2 seafarers around the globe sailing as we speak. And these are officers and ratings. With regards to officers, according to BIMCO, we will have some 20,000 shortage of seafarers, officers for that matter. With regards to ratings, we have sufficient supply. Now, this is the future now of seafarers. They will be on demand because the shipbuilding is overtaking the number of seafarers around the globe. So this is a good opportunity for the Filipino seafarers to shine. Take advantage of the opportunity. Unfortunately, as we all know here, we are having problems with EMSA, and our Marina are assuring us that we will overcome it. We will comply with the European Council's and European Union's decision to be favorable to us. Now, in the Philippine setting, there are about 20,000 maritime graduates every year that graduates from the maritime school. Only 5,000 or less are able to join vessels on board to take their shipboard training as a requirement to take OIC exams or officer in charge exams. All right. So indeed, we have a monumental task to really improve our seafarers, afford them good benefits, afford them more berths to take this shipboard training in order for the Filipino graduates to be able to take their exam. And then they can be part of the world maritime fleet. So I believe that's the future of our seafarers, Philippine setting, and most probably around the world, because we are the majority of the seafarers sailing around the globe. That's all I can say. Thank you.
Thank you, Captain Jean, for elaborating on, I guess, there are opportunities for Filipino seafarers, right? But also a lot of challenges, as mentioned by Captain Jean. So, so about the last question concerning the future of welfare, does Kirsten and Attorney Jenny have some last remarks before we close?
Yes, the seafaring industry or the maritime industry has been, well, here since time immemorial. And Filipinos have proven their skill to be one of the best in this industry. But I just want to echo on what Captain Jean has mentioned. We need to be at par, or we need to be above the standards of what other nations are looking for. So we have to maintain and comply with whatever regulations or whatever standards has been set in the maritime industry. The future is bright for the maritime or seafaring industry, not only because of the geographical context, not only of the Philippines but the whole world. So it will be one of the constant things that we will have, and we are together, us together with other stakeholders, are working closely together in order to achieve and in order to maintain and achieve this feat for Filipino seafarers. So so this will be a constant thing around the world, and different issues, different challenges will come in from time to time because of the changes that we experience, especially during the pandemic, which the maritime industry had shifted or has experienced a different dynamics. So that's all for now, and I want to thank you for this opportunity in sharing the insights in our seafarers and maritime industry.
Yeah, thank you, Attorney Jenny, for those insights as our, at least for this forum, representing the Seafarers Union. If you have any last remarks, Kirsten, would you like to say something?
Yeah, just some brief comments. I agree that there's a bright future ahead for seafarers, and that also seafarers from labor supplying countries are very much needed in the international shipping industry. And I think what is ahead is also bright for seafarers, is that when we look at the international mechanisms and at national legislation, there's more eye for protection of the seafarer, and that irrespective of your nationality, you may be entitled to certain conditions, and these conditions may be higher than the international minimum in certain areas, such as in Western Europe or Australia, the US. We also see it in Brazil. And that makes it very difficult sometimes to operate and see how you can be compliant. But I think the bottom line is that trend where there's more eye for the protection of seafarers and its conditions, irrespective of nationality, is in essence a good trend.
Yeah, thank you, Kirsten, for those last remarks. I should mention that there's a comment about the question of taxation. It is in particular about the UK and the Philippines. So thank you to John Kusley for that information. So it's not a question, it's just a comment. I encourage everyone to just read it. And I call on Lynn for to close our webinar. Lynn Bacani.
Yes, Prof. Velasco, our sincerest thanks to our speakers and panelists. We would like to give a certificate of appreciation to all of you. Let us first give to Kirsten Bull. Let me read the Certificate of Appreciation. The University of the Philippines School of Labor and Industrial Relations, in cooperation with Marino World, present this Certificate of Appreciation to Kirsten Bull, attorney at law, partner, Waibanga Advocaten, the Netherlands, in recognition of her valuable contribution as a main speaker on the topic Seafarers Minimum Wage in Commercial Vessels in a Dutch home port, implications for the Maritime Labor Convention 2006, held via Zoom on October 28, 2022, Friday, 4 o'clock to 6 p.m., with more than 130 registered participants from crewing, manning employers, seafarer unions and welfare organizations, governments, academia, and stakeholders in the promotion of decent work, as well as best practices in labor and employment relations. We thank you for your public service in sharing valuable expertise with the maritime seafarer community. The Certificate of Appreciation is signed by Professor Rosalio A. Aragon Jr., Officer in Charge, UP Solair, and yours truly, Lynn Bacani, Publisher of Marino World. We also give a Certificate of Appreciation to Captain Juanito Salvatierra Jr., Chairman of Joint Manning Group, JMG, in recognition of his valuable contribution as a panel speaker on the topic Seafarers Minimum Wage in Commercial Vessels in a Dutch home port, implications for the Maritime Labor Convention 2006. The Certificate of Appreciation is also signed by Professor Rosalio Aragon Jr., Officer in Charge, UP Solair, and Ms. Lynn Bacani, yours truly, Publisher of Marino World. And another Certificate of Appreciation for Attorney Generic Humphrey Morales, National Vice President for Operations, Associated Philippine Seafarers Union, PSU, in recognition of his valuable contribution as a panel speaker on the topic Seafarers Minimum Wage in Commercial Vessels in a Dutch home port, implications for the Maritime Labor Convention 2006, held via Zoom on October 28, 2022, Friday, 4 p.m. to 6 p.m. We thank you all for your public service in sharing valuable expertise with the maritime seafarer community. Thank you so much. Salamat po.
Thank you.
Maraming salamat sa lahat.
Yes,
Thanks to
Prof.
everybody.
Ben, this will
Yes, Prof.
formally end our session. And those, I just realized we have live FB, and maybe some of our participants are did not bother to log in anymore, but it's now in the live FB in our University Solair FB page. And thank you to Jack for doing that. So this is a start. This is a start of our efforts in the School of Labor and Industrial Relations, as my officer in charge, Acting Dean, has said. And we really thank the wonderful support and cooperation of Marino World, Lynn Bacani, for starting us out in this effort. And we look forward to see you live here in the Philippines, Kirsten, in the future, as well as Captain Salvatierra. Of course, Attorney Jenik is just with us because he is our student, but now he maybe has launched a career in maritime law. So thank you again for everyone for this effort. Thank you.
Professor Loy,
I thought you requested a photo.
Yes, I forgot to mention that Michael Agabao is in Nueva Ecija, and we are now being, I was afraid that we have to cancel this forum because of the incoming storm, but here we are brave enough, and of course we still have to brave the storm that is coming within the few days. Maybe rains are not getting heavy, but Mick, I hope you're still all right, and you could still ask everyone to open the camera, and we could take our souvenir photo.
Yes, Prof. Noy, I think everyone who are able to already has their cameras on. Let me take a photo already. Can we see all smiles?
Thank you.
In 3, 2, 1. Let me take another one. Take the photo in 3, 2, 1. Okay. Thank you very much.
Thank you, Mick.
We're
Thank you,
done.
Mick. And thank you to everyone.
Would also like
Thank
to
you.
announce that this will also be uploaded to our Marino World Online YouTube channel and
Thank you.
Facebook page, so that many could also still
Excellent.
watch this proceedings of
Excellent.
the webinar. Thank you.
Excellent. Thank
Thank
you. Thank you,
Thank
Christine.
you.
And
Bye.
see you.
Thank you for the organization.
Yes, yes. Thank you. Thank you very much. We will send you the certificates via email in a while. Thank you.
Bye, everyone. Thank you.
Thank you, Captain G.